Welcome back, sir. So in the last class we have done with the revision of offer and acceptance. We'll do the scanner on the offer and acceptance. Sir, in this scanner we are covering model test papers, revision test papers, previous exam questions of ICI. So if you can able to answer these questions, you are fit for the exam. Most probably similar kind of questions will repeat in the exam beta, because we are covering MTP, RTP questions from 1994 to 2025. Done. Amma? What is not visible? One second. So, yeah. The first question in the scanner will be define the term offer, explain the essential elements of a offer. What he is asking, beta? What is offer and what is the essential elements of a offer? Is asking define the term offer, question number 1, and explain the essentials of the offer, question number 2, and how the offer is different from the invitation to offer, question number 3. Three questions are there. He may give for 6 marks. If you define the offer, he will give 2 marks. And if you read the essentials of the offer, he will give 2 marks. And how offer is different from invitation to offer, you will get the 2 marks. 3 questions are there in the single question. This came in the 2019. And what is offer? Essentials of the offer 21 may be I button. So offer means when a person signifies to another person his willingness to do or abstain from doing any activity with a view to getting the consent of another for such activity or abstinence, then he said to have made a proposal. 2 marks milte beta if you define the offer. Essentials of the offer: it must create the legal relationship, it must be clear but not vague, it must be communicated, it must be made with a view to getting the consent of another, it may be conditional, it can be unconditional also. Offer should not contain any term non-comprehensive which amount to acceptance. It may be general or the specific, it can be expressed or implied. A statement of price is not a offer, that is mere declaration of intention, declaration of the intention. Next, offer is final expression of the willingness, and in case of invitation to offer, we are making the offers with the intention to make the negotiations. इसको बोलते हैं invitation to offer. So if you read the definition of the offer, 2 marks, essentials 2 marks, how offer is different from invitation to offer, you may get more 2 marks. Clear? Next, explain the type of contracts in the following agreements. A coolie in uniform picks up the luggage of A to be carried out of railway station without being asked by A. A is allowing, but taking the uniform, taking the luggage of the luggage in the railway station, implied offer. Which offer, beta? Following the A. So it is, which contract is this? Implied contract. Which contract? The implied contract. Obligation of finder of last goods. Which contract is this? Quasi contract. A contract with B for supply of the 100 tons of the sugar, but before supply is effected by fire accident in the factory, everything was lost. Before supply, void contract. Next question, madam. A shopkeeper displayed a pair of dress in the showroom with a price tag of 2000 rupees was attached to the dress. So there was a supermarket, beta. In that supermarket, we're displaying the dress with the price tag 2000 rupees. What is that? Invitation to offer. It's invitation to offer. So Miss Lovely looked at the tag, rushed to the cash counter. Then she asked the shopkeeper to receive the payment and pack the dress. What does it mean? Offer given by Lovely to shopkeeper. So displaying the dress in the shop is said to be invitation to offer. So we are taking the dress and going to cash counter, we are ready to offer the price. That is the offer given to shop. The shopkeeper refused to hand over the dress to Miss Lovely So shopkeeper said, we don't want to sell the dress. Can you file a case, beta? Yes or no? No. Shopkeeper refused to hand over the dress to Lovely in consideration of the price stated in the price tag attached to is. Miss Lovely seeks your advice whether she can sue the shopkeeper. Can she file a case on the shopkeeper? No. Because why what the shopkeeper is doing, beta? Refusing the offer. It's a rejection. It's a rejection of offer. Offer need not be accepted. The offer may be rejected also. Display of the goods with price tag. Rara. Invitation to offer. Selection of the goods. Offer. Selling the goods. Acceptance. Not selling the goods. Rejection. Then the same question came in the year 2018, 2004, 2019 also. Same question as it is. So provision of the law, offer should be different from the invitation to offer. We have read how offer is different from invitation to offer. Step number 2, facts to the parent case. In the parent case, so your shopkeeper is displaying the dress with price tag. Invitation to offer. So Lovely is selecting the dress. Offer. And shopkeeper is refused to sell it. It's a rejection. It's a next. Since it is rejected, no, but Miss Lovely can she show the shopkeeper? Bolo. No, she can't. We can't file a case. Step 1, step 2, step 3. Shambhu Dayal started a self-service system in a shop. What self-service system, beta? Supermarket. In supermarket, we have to choose our own goods, no, beta? Self-service system in a shop. Miss Srimati entered, beta. Starting the self-service system is a invitation to offer. Which offer? Supermarket. Srimati Prakash entered in the shop, took a basket. After taking the articles of her choice into the basket, reaching the cash counter for payment. What is this? Offer. Choosing the goods and reaching the cash counter is a offer. The cashier refused to accept the price. What is this? Can Shambhu Dayal be compelled to sell the article? So, can Srimati Prakash file a case on the Shambhu Dayal? Yes or no? She can't file a case. She can't insist. So, step number 1, invitation to offer. Step number 2, for accept the case. Step number 3, decision. Same question बेटा. ये देखो एक अब है बेटा ICA टेस्ट योर नॉलेज में आया बेटा आपका बुक में. The same question came 2004, 2013 and also 19, 21 also बेटा. Same question as it is. कितना बार आया? 5-6 बार आया बेटा. Start superstar. Actually this question came above 4 times, below 6 times, nearly 10 times. How offer is different from invitation to offer. Clear? Next question beta. Ashok goes to supermarket to buy a air conditioner. He is selecting a branded air conditioner having the price tag of 40,000 rupees after a discount of 3,000 rupees. What is this? Invitation to offer. Invitation to offer. Same question but 11th time. Ashok reaches the cash counter making the payment, but cashier says, sorry sir, Ashok reaching the cash counter is the offer. Sorry sir, the discount was up to yesterday. There was no discount from today. Hence you have to pay 43. Ashok got angry and insisted for 40. Stated with the reasons under the Indian contractor. Can Ashok enforce the cashier to sell the article discount? No. ये क्वेश्चन कब आया बेटा? अगस्त 2024 में आया बेटा. MTP में आया, सीरीज 2. क्लियर एवरीवन? नेक्स्ट, explain the modes of revocation of the offer. Last concept beta. How offer can be revoked? The offer can be revoked by notice, by lapse of time, by non-fulfillment of the condition, by death or insanity of the offerer or offeree, by counter offer, by non-acceptance or subsequent illegality. We discussed beta. Next, explain the modes of revocation. Same question beta. 2018 में आया. Same question. Next, Ramaswamy proposed to sell his house to Ramanathan. Ramanathan sent his acceptance by post. So what is he sending beta? Ordinary post. Which post? Which contains acceptance. Next day, Ramanathan sends a telegram withdrawing the acceptance. Subsequently, what is he sending telegram which contains the revocation of acceptance. Examine the validity of the acceptance as per Indian contract that in the light of the following. Telegram of revocation of acceptance was received by the Ramaswamy before letter of acceptance. First, what is reaching beta? Revocation. So what is effective? Revocation is effective. Contract is there or not there? Not there. Then revocation will be effective. So there will be no contract. Telegram of revocation, letter of acceptance, both reaching together. Generally, court will assume that a man of ordinary prudence will open the telegram first, which contains the revocation. Revocation will become effective. But you can prove contrary also. Done. कब आया बेटा 18 RTP. Same question 2006 में भी आया बेटा. Clear? So we should write when communication of offer ends, when communication of acceptance ends for the offerer and the offering. Step number 2. Step number 3. Step number 1, step number 2, step number 3. So yes, revocation of acceptance will be valid if Ramaswamy opens the telegram first. This would be normally in case of the rational man, and who reads it, acceptance stands revoked. That means if he opens the letter first, reads it, revocation of acceptance is not possible, contract will be existing. So we have is there two options. First, if he is opening the ordinary letter first, which contains acceptance, so acceptance will become effective. If he is open telegram first, telegram will be effective. Generally, a man of ordinary prudence will open the telegram only at the first instance. They are able to understand. Same question. Simultaneous delivery of the letter of acceptance and telegram containing the revocation of acceptance. Generally, a man of ordinary prudence will open the telegram first. But you can prove contrary also. You can prove that no, sir, I am opening the ordinary letter first. If you are unable to prove anything like that, no, court will assume that you are opening the telegram at the first mistake. Mr. U offered to sell his house to Mr. X for 15 lakhs. Mr. X accepted the offer by post. Ordinary post. X is sending the acceptance. On the very next day, X sent a telegram. Next day, he is sending the telegram revoking the acceptance, which reaches Mr. U before letter of acceptance. So revocation of the acceptance. What is reaching first, beta? Telegram is reaching first. So reaching the U before letter of acceptance. Is the revocation of acceptance is valid? Answer is yes. Answer is yes. Would it make a difference if both letter of acceptance and in the telegram revocation of acceptance reaches Mr. U at the same time? So here in the second case also, generally court will assume that man of ordinary prudence will open the telegram first. But questions repeat over and over. Questions repeat over and over. The same questions will be repeating so many number of the times. Done. Comment on the following 2019 में पूछो बेटा. Letter of acceptance must be absolute and unqualified. True or false? Acceptance must be absolute 100% without any qualification, modification, variation, because qualified acceptance will amount to counter offer. Which offer? Offer first essential. Acceptance में offer must be absolute and unqualified. Next, acceptance must be in the prescribed mode. Yes or no? If offerer prescribes the specific manner of acceptance, you have to accept only in the specified manner. Otherwise, reasonable manner. Which manner? Second, next question. Mr. A sends that question beta. Clear? A sends an offer to B to sell his second hand car for 1,40,000 with a condition that if B does not give reply within a week, he A shall treat offer is accepted. Is A correct? Is A correct in his proposition? What shall be the position if B communicates its acceptance after 1 week? This question came in the year November 2019 RTP. Answer my question. So if you observe here, A said to B, please give reply by within 1 week. How many days? 1 week. If it does not give reply in 1 week, I assume you are giving the acceptance. Can I write the letter like that? First of the offer itself is invalid. We have seen one heading, no term non-compliance of which amount to acceptance. What is the meaning of complying? Following. Following means you have to give reply within 1 week and not giving reply. Can you assume that it is acceptance? Can you assume it is acceptance? No. So offer itself is invalid. A sends an offer to B to sell his car, second-hand car for 1,50,000 with the condition that if B does not give reply within a week, A shall treat it as accepted. No term non-compliance which amount to acceptance. The same example we have discussed. Yes or no? Is A is correct in his proposition? No, he is not correct in his proposition. Let that the proposal itself is bad proposal. What shall be the position if B communicate the acceptance after 1 week? So whenever he is communicating the acceptance, by that time, from that time only it will become effective. Then clear? Step number 1 we should write about the no term non-compliance which amount to acceptance. Step number 2 facts. So in the given problem, if B remains silent, it doesn't amount to acceptance. So A is wrong in his proposition. Then the same question beta. When ये कब आया beta? November 2000 article में same question. Next, A sends an offer to B to sell his second-hand car. Same question beta upper wala as it is. Clear? Next, question number 23. Good Girl Soap Company advertised that it would give a reward of 1,000 rupees who developed a skin disease after using Good Girl Soap of the company for certain period as per the printed directions. ये क्या है बेटा? Which offer is this? General offer. Company advertised. If you use the medicine as per printed directions, you will not get the skin disease. Miss Raki purchased a soap advertised Good Girl, and Miss Raki developed a skin disease in spite of using the soap as per the printed directions. What is the meaning of the using the medicine as per printed directions? Acceptance. It is deemed to be acceptance. She claimed reward of 1,000 rupees. The company refused the reward on the ground that offer was not made to her and that in any case she is not communicated the acceptance. But advertisement is a general offer using the medicine as per the printed directions is a deemed acceptance. Which acceptance? Decide whether Miss Raki can claim the reward or not. Can she claim reward? Refer the case law if there is any. He's asking the relevant case law also. He's asking the case law name also. Carlyle versus Carbolic Smoke Ball Company. There, what will be there, beta? Skin disease, nose disease, influenza. In place of influenza, it become skin disease. Everything remains same. Then, step number 1, we should write about the general offer and Carlyle versus Carbolic Smoke Ball Company. And step number 2 about the Good Girl Soap Company. Step number 3, yes, Raki can claim the reward of the 1,000 because the advertisement is a general offer. Using as per the printed directions is a deemed acceptance. So offer is there, acceptance is there. There is a valid contract is there between the Good Girl Soap and Raki. Getting confidence? Able to understand? So I will upload this daily, watch it daily, write, लिखना बेटा. Scanner को क्या करना? लिखना, पढ़ना नहीं. Explain in brief the rules regarding to acceptance of an offer. Define acceptance. What are the essentials of acceptance? 4 marks. If you read that acceptance, 2 marks. Essentials of 2 marks. Date question है बेटा. देखो 2012, 21 है ना बेटा. 2003, 2020, 2019. Question came so many times. How many times? So acceptance must be absolute and it must be communicated or signified. Signified means communicated. It must be communicated to offeree, communicated by offeree communicated to offerer within the specified time before it is lapsed. Then validity of revocation of acceptance where telegram containing the revocation received before. But here two letters are there. Ordinary letter containing the acceptance and telegram containing the revocation of acceptance. What is reaching first, beta? Telegram. 2006. What is the revocation of acceptance when telegram containing the revocation receiving before? If telegram is reaching before, generally a court will assume that man of the ordinary prudence will open the telegram first, so revocation will become effective. Then date question, beta. Cross offer and counter offer and offer different from invitation to offer. 2 plus 2 plus 2 6 marks. Next, what are the exceptional cases when silence may be treated as the acceptance? So generally silence does not amount to acceptance, but silence may become the acceptance when where offeree having the reasonable opportunity to reject the offered goods but enjoys or avails the benefit. Actually you are ordering thumbs up but I'm supplying maza. You have right to object it, reject it. Instead of rejecting, you are taking that maza. That is deemed to be silence will amount to acceptance. You are not rejecting, you are silent, but you are using it, remember? The deemed to be acceptance. Where the previous dealing shows that the offeree has given the offerer a reason to believe that silence of the offeree was manifestation of the acceptance based on the track record. Even you have a right to reject, you are not rejecting. What does it mean? It's accepting. Then a special question, beta. 21 mein aaya. Next, Miss Shakuntala puts an application to be a teacher in a school. Remember, school principal. Miss Shakuntala puts an application to be teacher in a school. She was appointed by trust of the school. Her friend who works in the same school informs her about her appointment informally. Kavya informed to Manoj that yes, you will be the next principal. But later, due to some internal reasons, her appointment was cancelled. Can Miss Shakuntala claim the damages? Yes or no? No, because in a famous case, which case, beta? Powell versus Lee. Powell versus Lee. So somebody was applying for the school principal post. Subsequently, one of the team members said that you will be next principal. Then he went to sweet house. He was bringing the sweet. Subsequently, they changed the mindset. But actually, who gave the who advertisement given by school is the invitation to offer. Advertisement is the invitation to offer. Submitting resume is the offer. You give the offer to whom, beta? School, but not to particular team member, committee member. Yes, and who can communicate the acceptance? School. Here, who is communicating? One of the committee member. Yes, sir. No, sir. Clear, beta? So here, acceptance must be communicated by the offeree. If any third party is given the acceptance, that is not a valid. Clear na? Same question came in the exam, beta. Second, one more time. Beta, I said Mr. Parth applied for the job as a principal in the school. The school management decided to appoint to him. One member of the school managing committee privately informed Mr. Parth that he was appointed, but official communication was not given by the school. Who can give the communication? But school. But who is giving? One of the member privately. Later, the management of the school decided to appoint someone else as the principal. Mr. Parth filed a suit against the school for cancellation of his appointment and claimed damages for the loss of salary. Can he claim the salary? Can he file a case? State with reasons. Will Mr. Parth be successful? The same question, beta. Advertisement given by school for the post of the principal is an invitation to offer. and resume submission is deemed to be offer given to whom? School. Who can give acceptance beta? Acceptance who should give beta? School. Who is giving here? One third party. That is not valid acceptance at all in the eyes of law. Then next question. Same question beta. 2003. Next, state whether there is a contract in the following case or not. A engages B to do certain work and remuneration is to be fixed by C. Valid and valid. Contract. In case of contract, remuneration can be fixed by the third party also. Say express contract. A and B promises to pay for the studies of their maid son. It is a social agreement. Which agreement beta? Not mandatory. And A takes a seat in the public bus. Which bus? Public bus. So it's a quasi contract is we have to pay for the price. A chartered accountant promises to help his friend to file a income tax return. It is a social agreement. Which agreement? What are the rules for the completion of communication of offer and acceptance by post? If sending the letter offer and acceptance by post, when communication of offer ends, once it reaches the offeree. And what about the acceptance for the offerer? Once it is posted by the offeree. And for the offeree, once it reaches the offerer. Yes sir, no sir. Offeree can withdraw his acceptance before it reaches the offerer through speedier mode of communication. Then next. Mr. H send a telegram to K asking, will you sell us bumper hall pen? Telegraph the lowest price. K replied through a telegram, the lowest cash price for the bumper hall pen will be 50,000 rupees. H replies through telegram, we agreed to buy bumper hall pen for the 50,000 rupees asked by you. Send the title deeds. Explain the comment. Beta, here H quoting the price is merely invitation to offer. Thus, K has merely replied to H offer query by sending the price quotation, agreeing to accepting the price of the quotation does not amount to acceptance. Thus, there is no contract. I am asking, can you please tell me the price of the pen? What is this? Invitation to offer. You said, I want to sell my pen for 50,000 rupees. What is that? Offer. I may accept it, I may not accept it. Then beta. Emendra, same example is there in the IC material. Next. X purchased a steamer ticket for traveling from Dublin to Whitehaven. The terms and conditions were printed on the back side of the ticket. Where beta? Back. One of the conditions prescribes that shipping company shall not be liable for any event of loss, injury, delay to the passengers or their luggage. X did not see the back of the ticket. There was no instructions on the face. But standard form of offers must be on the face, but not on the back. If it is on the back, there must be indication on the face. So there was no instructions on the face of the ticket to see back for terms and conditions. During the journey, X luggage was lost due to negligence of the staff on the board. X claims from the shipping company, which denies its liability on the grounds that the company has expressly excluded its liability at the time of formation of contract. Comment whether the shipping company is tenable. Is it tenable, beta? Shipping company said already we informed to you, so we are not responsible. The shipping company is right? No, because you have to inform the standard form of offers on the face, but not on the back. If it is on the back, there must be indication on the face, but there is no indication on the face of the instructions. Standard form of offers. You have discussed a case, no beta? Same case la. Next. B send it clear. Step number 1. Standard form of offers must be on the face but not on the back. If it is on the back, there must be indication on the face. Otherwise, not binding on the customer. Step number 2. In the present case, the shipping company is writing the facts on the back but not on the face, and there is no indication on the face. So, standard form of offers is not binding on the customer. Step number 3. Shipping company will not win the case. Customer will win the case. Then B sent a draft agreement relating to supply of the coal and coal and coke to a manager of the railway company for his acceptance. The manager wrote approved on the same but put the draft in the drawer of the table, intending to send it to company solicitors for formal contract to be drawn. By oversight, the draft agreement remained in the drawer. But acceptance must be communicated. Mere mental determination does not amount to acceptance. In this case, the railway company sending a offer letter to the particular coal supplier. Coal supplier write in the yes sir, we want to supply coal. Whether it is communicated, he is keeping in the drawer. He is keeping in his drawer and forgot to send it. Acceptance is not communicated. Because in a famous case law for this, what is that case law? Brogdon versus Metropolitan Railway Company. If you observe this, same as Brogdon versus Metropolitan Railway Company, as it is. Here, acceptance given is valid and invalid? Perfectly invalid, because it was never communicated. Yes or no, sir? Clear? Step number 1, we should write acceptance must be communicated. Mere mental determination does not amount to acceptance. Facts of present case. In this case, so B was getting the offer for supplying of the coal. B wrote the acceptance letter, but he kept in the drawer, forgot to send it to railway company. Decision. Acceptance is not valid, so there was no binding contract between the supplier of the coal and the railway company. Then same question beta. देखो बेटा कब आया, 22 में आया, ऐसे क्वेश्चन पे TYK में आया and 21 में भी आया. Mr. B makes a proposal to Mr. S by post to sell his house for 10 lakhs and posted ये अलग वाला बेटा, and posted the letter on 10th April 2020. The letter reaches S on the 12th April. He reads the letter on 13th. Mr. S sends his acceptance beta. When we writing letter beta? 10th April 20, writing the letter. And the letter reaches S on the 12th. Reaches. And he reads the letter on 13th. When offer is said to be communicated? 13th. Clear na? Communication of offer ends once it reaches to the offeree. When it is reaching the offeree's mind? 13th. So he reads the letter on 13th April. Mr. S sends his letter of acceptance on the 16th. On 16/4/20. Accepted. And letter reaches B on the 20th. Reaching you on the 24th. It is reaching the offerer. On 17th April 20th, S changed his mind, sends a telegram withdrawing his acceptance. On 17/4, sending the telegram to revoke his acceptance. The telegram reaches on the 19th. But when ordinary letter containing acceptance is reaching 20th, when telegram is reaching containing revocation 19th, so what is effective? telegram is effective. Telegram reaches Mr. B on 1920. Examine the following. On which date offer made by B will be complete? 13th. Discuss the validity of the acceptance. Is it valid with acceptance? No, because what is reaching first? Telegram, which contains revocation of acceptance. What would be validity of the acceptance if letter of revocation and letter of acceptance reach together? Still, generally, court will assume that a man of ordinary prudence will open the telegram first, which contains revocation. Revocation will becomes. Then questions repeat or this is the answer given by IC, but a lamba answer. Next. Clear? Bola bachcho. Next question. We discussed till here, right? 41. So we are seeing nearly 50 plus questions better from this topic. Do you think something else will come in the exam? I am leaking your question paper. Mr. A offered to sell 25 chairs to B at the rate of 1500 rupees per chair on 12 to 24, and A promised B that he would keep that offer open till 15 to 24. However, on 13 to 24, he sold those chairs to Mr. C 70 per chair without the knowledge of the B. Mr. B communicated the acceptance of the above on the 14th. Advice with reference to provisions of the Indian Contract Act whether B can claim the damages. Beta, A said to B, I want to supply the 25 chairs. Each chair at the rate of the 1500. When he said beta 12 to 24. Clear na? So A offered to sell 25 chairs to B, each chair 1500 on 12, 5, 24. A promised to B that he would keep the offer open till 15th. Till 15th, I will not revoke my offer. Yes sir, no sir. Clear na beta? However, on 13th to 24, he sold those shares to C. So subsequently, on 13th, he sold the same shares to C. 25 shares, the shares at the rate of the 1700. But whether B is accepting before 13th? No. Yes. But it becomes valid contract if B is accepting. Whether B is accepting, when we give the offer, 12th, it is remain open. No one is accepted. Done na beta. On 13th, who is accepting? C is accepting. Then beta. Then so Mr. B communicate the acceptance the above offer on 14th. Advice with reference to provisions of the Indian Contract Act, can B claim the damages? Can he B claim the damages? No. Why? Because you are not accepting. After B is accepting, if you are selling it to C, B can claim the damages. In terms of section 5, a proposal can be revoked at any time before communication of acceptance is complete as against the proposer or offerer. Yes sir, no sir. Whether B is accepting? No. Before B is accepting, we sold it to someone else. Clear na beta? So as per, accordingly, an offer may be revoked by the offerer before it is accepted. This is the crux. Offer can be revoked. Even though he had originally agreed to hold it to open for different period of time, so long it is a mere offer, it cannot be it can be withdrawn whenever offer. Simply beta, bolo, offer can be revoked by the offerer at any time before it is accepted. Step number 1. Yes sir, no sir. So when we give the offer 12th, when we are revoking 13th, we are selling it to, we are giving the same offer to C. Who is accepting? C is accepting. Then beta. Can B claim damages? Because before it is accepted, A is revoking his offer. If A is selling it to C after B is accepting, then B can claim the damages. Then Next, G. Send his servant L to trace his missing nephew. He then announced that anybody who traced his nephew would be entitled to certain reward. What is this, beta? He is announcing general offer. Which offer? L traced the boy in ignorance of the announcement. So, for L, offer is not communicated. Offer is not. Subsequently, when he came to know about the reward, he claimed it. Decided on the basis of the Indian Contract Act whether contention of the L is valid. Valid or invalid? By one can accept the offer if he has the knowledge. Since the offer is not communicated to him, how can he give acceptance? Is it possible? Bolo. So here we should write about general offer. Which offer, beta? General offer. And general offer can be accepted if it is communicated to him. Since it is not communicated, he cannot. So here we should write about that Lalman Shukla versus Gauri Dutt. L ante Lalman Shukla, G means Gauri Dutt. So since employee don't know about the offer when he is returning the particular kid, this guy cannot claim the any reward. Then A proposes B to purchase his Android mobile for 5,000 rupees, and if no reply by him in a week, it would be assumed that B had accepted the proposal. Decide the validity of the agreement. Valid and valid. Why? No term non-compliance of which amount to acceptance. Offer cannot say like that. Yes or no, sir? So here offer said if you don't give reply by in a week, I deem it to be acceptance. That is not a valid offer at all in the eyes of law. Clear? A supplier send a telegram, a draft agreement relating to supply of the coal to manager of the railway company, Metropolitan Railway Company, for its acceptance. The manager wrote the word approved on the same, but puts in a draft agreement in the drawer of the table. Same question, beta. Acceptance must be communicated. Mere mental determination does not amount to acceptance. Clear, beta? Step number 1. Here, acceptance letter is written but not communicated to the offerer. So there is not valid acceptance. So there is no binding contract. A makes a proposal to B by post to sell his house for 50 lakhs, and the letter containing the offer is posted on 10th March and reaches B on the 12th, but he reads it on the 15th, on which date offer is said to be communicated. When he is posting, beta? 10th March he is posting. When it is reaching 12th March, when he is reading 15th March, when offer is said to be communicated on 15th, writing, posting and reading. Offer comes to an end once it reaches the offerer. Done. Next question. Mr. B makes a proposal to Mr. S by post to sell his house for 10 lakhs. Same question, but upper wala. Rather than what we have discussed already. What are the modes of revocation of offer? We discussed already. Done, beta. So with this we have done with the scanner for the second chapter also. Done. So remaining part will discuss in the next class. Have a great time. Enjoy the day. Prepare well. Is signing off. Take care.